A very good morning, everyone, and welcome to our latest in the series of Skybound Capital webinars. We say good morning to all our colleagues and friends here in South Africa. Good afternoon to colleagues in Australia and Hong Kong, and wherever our friends of Skybound Capital are joining us from around the world. Welcome to our latest webinar, and it's a very important discussion we have today. We have Denise Williams joining us from Durban, Skybound Executor Services. And Denise handles a part of our business that is very important, and yet one which people seem to have a great deal of trouble talking about. And we're immensely grateful to Denise for taking on this tricky topic, this difficult topic for a lot of people around estates and testamentary services. So we're talking today testamentary and living wills, deceased estates, testamentary trusts, which forms such a vital part of the investment universe. I was chatting to Denise earlier in the week and saying that whenever we make a significant investment, whether it's in property or in a fund, our financial situation changes fundamentally, and do we have our affairs in order? And this is the question that Denise asks clients first and foremost: are your affairs in order, and how can I help you to do that? And she's been doing this for a very long time. She has a long-standing relationship with Skybound Capital, and we're delighted to have her as part of the family and with us today to discuss various topics around wills and estates. So Denise, welcome. And perhaps we should start with the basics. And if you could tell us about the various services that you offer as part of ETS, Estates and Testamentary Services.
Thank you very much for having me as your guest today. It's a great privilege to be talking to everyone. Thank you. Okay, we offer the service we offer free drafting of wills for all of our clients. There's no charge for the will, both local wills and foreign wills. We also do as a free service the living wills and also free safe custody of the wills. Unlike our competitors who would charge for the drafting of a will, for all alterations to wills, and also an annual safe custody fee. So that is a free service we charge. We consult with the clients on a one-on-one basis if possible to take the instructions. So we build a good working relationship with the client. We have a very, very good track record of handling deceased estates. I've been in the industry for over 45 years. I'm giving away my age now, but I started when I was 10. Now we offer a very personal, we encourage participation, family participation in being appointed as co-executors with ourselves and co-trustees so that they have a hands-on as to what's happening in the estate and the trusts.
And I suppose, Denise, personal service is paramount in this situation, because literally every person's circumstances, every family's circumstances are different.
Exactly, yes. And we offer a very one-on-one. We try and sit down face-to-face in front of you when we take the instructions to do the will. So we build a good relationship before your demise. And then at the time of winding up a deceased estate, we deal hands-on with one-on-one with all the heirs if we can, if they're local. If they're not local, we would do Zoom meetings or Skype calls or whatever. So we keep the family and the heirs and the beneficiaries very, very involved in the administration process so that they know exactly what's going on at all times. We also work on those estates on a daily basis. So I don't work on a diary system whereby I would work on the estate today and do an email and then only respond in 3 weeks' time.
You referred to Zoom calls and the way we've been doing business in the last few months by necessity. But in your case, I guess this is actually a potential advantage, that you can actually have families who are geographically apart having these discussions on a more regular basis in an environment which has become comfortable.
Yes, it's a fairly new thing to all of us, and it's working really, really well. In the first 5 weeks of lockdown, I did Zoom calls with people that have done wills with, and also as families in deceased estates, and it really, really worked well. People had the time to spend, and in the first 5 weeks, we actually amended 203 wills. We people's wills were not currently up to date. So they had time to go back, visit their wills, have a look at it. They got married, got divorced, had children. So it's really, really working very well, and it's a thing of the future.
And Denise, before we get into some of the specifics, how important is it to have a qualified executor dealing with your will and your estate?
It's so important. Today, any estate that is over 250,000 Rand in value, which today is a motor vehicle, so any estate which is over 250,000 in value, the master will insist that you have a recognized executor assisting you in winding up that estate. Because with respect, if you nominate your son or your next door neighbor as your executor, he doesn't know what to do. There are a whole lot of administration processes and laws that we have to abide for, advertising and all that type of thing. So if you have anybody that is an unrecognized executor nominated as your executor in your will, I suggest you go back and revisit it, because if you have such a situation, the master's going to insist that you be assisted by a practicing attorney to wind up that estate. That attorney that you then approach is not governed by the set legal tariff of 3.5%. So that attorney then is at liberty to charge you an hourly rate in winding up that estate. Some attorneys' hourly fees are 5,000 Rand an hour. You might work on that estate for a period of 2 years. So it can cost a lot more if you don't have a recognized executor.
Now, Denise, in my intro, I spoke about your subject matter as being something that people tend to put off. It's something they don't like to talk about. And what I'd like to get into is some of the myths around wills and estates, because I think sometimes in order to goad people into action, you need to be quite hardcore with the facts. You really need to spell it out how important these discussions are and how much peace of mind they can actually bring you if you get them right. So we're going to talk about some myths. And I have to put my hand up and say, over the course of my life, I've been guilty of thinking a lot of these myths are true. So number one, it can wait. I'm too busy. It's not a priority. My will can wait.
No, your will is probably definitely the most important document that you'll ever sign in your life. It encompasses everything you've ever worked for, everything you own at the time of your death. And it should encompass what your wishes are with regard to the disposal of those assets. So if you die intestate without a will, there are laws that are governed according to the laws of intestacy, and the estate would then be wound up according to those laws. And that might not necessarily be how you would want your estate distributed. So there would be beneficiaries that would benefit according to the laws of intestacy in your estate, being bloodline heirs, and that might not necessarily be your wish. So it is so important to know that your will is up to date, it's peace of mind, it's a huge weight off your shoulder. You know, people run around and they think I'm too busy to do a will, but really it is the most important thing you should attend to.
That's pretty unambiguous. That's going to be a takeout from this webinar. The most important document you'll sign in your life. So, and that's from somebody who's been doing it, as you said, since the age of 10. So we will take your word on that one. Myth number 2, Denise, it's okay to die without a will.
Definitely not. If you die intestate, as I've said earlier, there are laws that would apply. If you die without a will, and then the law then determines who gets what. You could be inadvertently condemning your spouse to a life of trying to survive on only a child share in your estate. So a surviving spouse does not automatically inherit your entire estate if you die without a will. She will inherit the child share or the first 250,000 Rand in an estate, which can cause severe financial problems in her life. Also, if you die without a will and you have minor children, the monies will then go, their share go into the guardian's fund, and that is something you want to avoid at all costs. At present, the Guardian's Fund is in big trouble in this country. There aren't monies, they've been used. So children that are turning 18, that monies were placed in a Guardian's Fund, are not in a position to claim those monies. The monies are actually lost.
And if you aren't formally married, Denise, would you have a life partner? How is that affected by the fact that you don't have a will?
Okay, so if you aren't formally married, your life partner is not automatically, according to law, considered your spouse. So you might have been in a relationship with a life partner for a very long time, and this could end up in a very bitter dispute with your family over rights of inheritances. So that person might make a claim against your estate for maintenance because she might not have worked or he might not have worked. You might have been supporting them. They don't automatically then qualify to inherit from your estate because common law marriages in this country are not recognized. So very, very important to deal with those issues.
So combining the necessity for a will and also a qualified executor, it's also important to note, I think, that families are not authorized to deal directly with SARS, with attorneys, or with insurance providers. Is that correct?
Correct, yes. So that the families might want to go along and claim a policy or whatever, or claim anything from SARS in respect of companies that are in deceased estates and that type of thing. So they're not automatic. You have to have a recognized executor. You have to work through the executor. I've even had situations where the insurance policies and pension monies that fall directly out of the estate, the families have tried to deal with the insurers, and they've insisted that they obtain letters of executorship first. So you have to work closely with your executor in proceeding with winding up the estate, even for assets outside of the estate. The insurers have to know that the estate is solvent, for example, before they pay out policies. So there are all kinds of rules that apply. Pension monies in retirement annuities fall out of the estate. Those go directly to beneficiaries. You might have nominated a beneficiary, and it's still at the discretion of that pension fund to pay, or annuities to pay at their discretion.
So to sum up what you said in the last couple of answers, fair to say there's absolutely no advantage at all to dying interstate?
No advantage at all. Definitely not. Can cause huge, huge heartache and problems.
On to myth number 3, which perhaps you can expand on. You hear people say, I'm single and I have no assets, so a will is pointless. How would you respond to that?
Well, firstly, you will have some assets. There's a bank account, perhaps, a motor vehicle, there's employer's pension fund. Circumstances may change very quickly in your life. For example, you could receive an inheritance. You could die as a result of a motor accident, and your estate could go from being insolvent to very, very solvent. I did a deceased estate a few years ago where a gentleman didn't want to do a will with me. He said, I owe more than what I've got. I insisted he do a will. He had minor children. He was involved in a car accident. We did a huge MBA motor accident claim, and we claimed $2 million. So his estate went for loss of income. His estate went from an insolvent estate to a very solvent estate. Now, had he not had a will, those monies would have been claimed and gone to the guardian's fund and probably lost for those children. So very important. So it doesn't matter whether you're single, married, divorced. Everybody over the age of 18 should actually have a will.
Let's move on to the role of a spouse, and another of the myths that we've spoken about in the past around power of attorney. A common response to the suggestion of having a valid will is, oh, my spouse holds my power of attorney, so therefore that's all he or she would need.
A huge myth. Powers of attorneys fall away immediately on death. So if your spouse has your power of attorney, you die, your spouse cannot use that power of attorney once you have passed away. So the power of attorney dies with you. Then the estate, the executor would kick in and take over the estate. So that the spouse has no right to go and draw funds from your estate in your absence. Even a power of attorney, another myth is that if there is a power of attorney in place and you get Alzheimer's, your spouse can work on that power of attorney. The person who gives the power of attorney has to be of sound mind at all times that that power of attorney is being used. So he or she needs to know and understand what the spouse is using that power of attorney for at all times. So if they have Alzheimer's and your wife is using the power of attorney, actually illegal. You then need to have a curator appointed. So there's a huge myth around power of attorneys. I get requested to do power of attorneys all the time. A lot of financial institutions have their own power of attorneys and they won't use a general power of attorney. So if you have a Nedbank bank account, you need to go into Nedbank and sign their own power of attorney. So the power of attorneys cause huge problems too.
So just to reiterate, a power of attorney, to use your parlance, it's fairly straightforward, dies with you.
Correct. And a lot of people don't realize that.
Here's another myth for you to respond to. And you hear this often as well. It's easy to draw up a will. I can just do it myself. And to quote the old parlance, using will in a different way, that old saying, where there's a will, there's a way. Well, there may not be a way with regards to drawing up your own will. Just let's reiterate here that I guess the dangers or the challenges of trying to do it yourself without the necessary skills.
Immense. Honestly, I can write a book alone on all these problems from people drawing up their own wills. There is no legal requirement that you have to have a professional to draw up your will. But before you go and buy a template will in the CNA or copy someone else's will, consider huge amount of common pitfalls. Your will must comply with legal formalities to be valid. It doesn't pass muster for any reason. Your heir will have to make an extensive application to court to have it validated. So if you've done a will and you haven't complied with the rules and regulations of that will being signed and witnessed it by two independent persons, nobody that's going to benefit by your will, it needs to be dated. I've got a case right now where a lady chose her life partner as her beneficiary of her will. He went into the CNA, he bought the standard will, he handwrote the will for himself, for her. She signed it. They got two witnesses, but he appointed himself as the sole beneficiary, the sole executor of the will, and he signed as a witness to that will. So those were three huge errors he made in a self-made will. You cannot be the executor and a beneficiary if you're not bloodline. He signed as a witness, so you cannot witness the will that you're benefiting from. So it's a huge inheritance, and he is disqualified from inheriting because he made that mistake. I've had lots of cases where people have gone in and bought a simple will. A gentleman bought a will and he wrote, I leave everything to my wife. He signed, dated, got two witnesses. He then filed it away. He got divorced some years later. His new wife, he remarried. His new wife said, you need to make a will. He said, here's a will. I've left everything to you, my wife. When I die one day, just take it along to somebody. She came to see me when he died. And when I had a look at the date of marriage and the date of will, the date of the will was preceded the date of marriage. So it was the wife he was married to at the time that he made the will, which he'd since divorced. She ended up inheriting in terms of the will. The scary stuff.
So there are a lot of other legal documents that need to be taken into account. And perhaps you could talk about some of those. If we talk about antenuptial contracts, for example, in the case of marriage, foreign assets that you may hold, which require a separate will, a so-called foreign will. So what you're saying here really is there's no one-size-fits-all solution. And that, to our previous point, every person and every family circumstances are by definition different.
Exactly. Your marital status needs to be taken into account when drawing up a will. There are plenty of grey areas which are best left to professionals when you do draw up a will. If you have a foreign will, you will need, if you have foreign assets, I strongly suggest that you do a foreign will. You can do one universal will, but very often if you have one universal will applying to assets inside and outside of South Africa, the Master of the High Court in South Africa, if you're domiciled in South Africa, can insist that you bring all those foreign assets back to South Africa through your South African estate. So I encourage that if you have a foreign will, those assets then can be left where they are at the choice of your beneficiaries, which is a huge advantage. You don't want to have to bring assets back into the country if you don't need to. So the way you are married determines how your estate is also going to be distributed. If you're married in community of property, spouse automatically has to inherit half of everything of your estate. For example, if you're married in community of property, assets of both parties, even the surviving spouse, are brought into the estate of the first dying. So both parties' assets are brought into the estate. The estate fees and executors' fees and administration costs are calculated on the gross value of the joint estate. And then Half of the joint estate is automatically distributed back to the surviving spouse in terms of community of property marriage, the laws, and then the other half can be distributed in terms of your will. So very important, the same as if you married antenuptial with accrual, the accrued portion of your marriage that you've accrued during your marriage, that gets split according to that accrual. Irrespective of what your wishes might be in your will, you might have got married, a second marriage and got married ANC accrual, you do a will and you bequeath everything to your children. Your surviving spouse would have a claim against your estate, depending on how you married. All these things need to be brought into your attention at the time of doing your will.
And Denise, let's talk about the importance for those who are left behind of clearly defined outcomes from the will and proper drafting, and how much pain it actually takes away dealing with this. I mean, for the people that are left behind.
Huge problems. I've had situations where the brothers and sisters don't talk to each other for the rest of their lives again because of a badly drafted will by a father or a parent that has made a mistake in the will. I had a case a few years ago where a person left, it was a foreign will, and it had been translated from French into English, and one word had been left out of the will, and it made a huge difference in the interpretation of that will, where they said, I bequeath 50,000 each to, I bequeath 50,000 Rand to Mary and Joyce, and they left the word each out. So it was then interpreted that it was 50,000 between Mary and Joyce, each getting 25,000. And because the word each would be left out, it made a huge difference to the inheritance. So badly drafted wills are very, very dangerous and cause huge problems amongst families and heirs because they can be interpreted completely different to what the intention was of the deceased.
We are seeing some questions come in via the Q&A function on Zoom. So we are going to address those. So I'd like to encourage you, if you do have questions for Denise, you may want to talk to her after the webinar, and we will certainly arrange for that. But we're also going to run a couple of little poll questions. They're very simple questions. We've got over 100 participants on this call. I'm going to ask Ross to put up our first poll question. It's a very, very simple question, but it's going to be fascinating. There you go. Do you have a will? Yes or no? We're going to just give you 10 seconds to respond to that and submit your answer, and then Ross will give us the answers to that. And then we have a follow-up question. There you go. Less than 2/3 of the people on the call actually have a will. So we're going to have a follow-up question to that. In fact, Ross, I'm going to suggest that we have the follow-up question right now. And the follow-up question can only be answered by the 63% of the people who have a will. When did you last update your will? I have to say that I am going to have to click an answer that I'm not proud of on this particular one. So Denise is going to be getting a private call from me. So we ask you to submit your answers to that. So 63% of us on this call have a will. Of those 63%, 37% of the 63 last updated their will more than 2 years ago. So I think the 6% and 8% respectively that have done 0 to 3 or 3 to 6 months ago. Denise, you'd be very happy with those people on the call, but it does come across to me that there's quite a lot of potential business just amongst our own on this webinar, because you've brought some really important things to light. Just getting back to some of the problem areas in drafting your own will. Give us an example of testamentary trusts and how they can work, Denise.
Okay, a testamentary trust can run very, very well. There are two kinds of trusts. So I'm just going to quickly deviate and say there's a family trust or an inter vivos trust. We're not talking those trusts. Those are trusts you create now whilst you're alive. A testamentary trust is a trust that comes into being on your death. So in the event of you having minor children, you wanting to bequeath monies for those minor children's education or whatever their maintenance, you would create a testamentary trust in terms of your will if you don't have an existing family trust that you would want funds to go to. The testamentary trusts run very, very well. They're very inexpensive to administer. They actually cost us more to run than what we get from a fee. The trust is, to create a testamentary trust, the fee is 1% of the capital coming into that trust. The annual administration fee to run that trust is 6% of the income only, not capital. And then dissolution of the trust when the child turns 25 or whatever is 1.5%. They run very well. I had a case a few years ago, a good few years ago, where a gentleman, a Natal rugby player, came into my office and asked me please to do a will. He just got divorced. He had a 7-year-old child, and he wanted everything to go into a trust for the 7-year-old child. One of the specifications in that trust was that I maintain a family farm, which he had inherited up in the Berg, and it had been passed from generation to generation. He then said he wanted this farm to be maintained and retained in that trust, and when the child turned 25, for the farm to be given to the child. He was then murdered on the farm, and some months after I did the will, the child was 7 years old. I now had to keep this farm until the child turned 25. It's a huge dilemma in my life. I got in my car and I went up to have a look at the farm. It was totally derelict. He wasn't even farming anything. I then had the problem of now I had to maintain this farm until the 7-year-old turned 25. What was I going to do? Long story short, I advertised for a manager to come and live on the farm, a family man with children. I said he could then live on the farm free as long as he maintained the farm, and he could have an area of land to farm, and I then needed to look at generating an income for this child from the other part of the farm. I then got Sappy in to do soil tests, and long story short, we did 3 plantings before that child turned 25. We turned that farm into a huge asset in the estate. We made millions. I was able to take the child out of mainstream school. We put him in private education. When he was old enough, we paid for pilot flying lessons. He became a pilot. So it turned out into a beautiful story at the end of the day. When that child turned 25, he had a farm that was worth absolute millions. So testamentary trusts, and one thing I learned when I was studying was that if you treat every estate or every trust as you would want your own to be treated, one day you can't go wrong.
I'm going to carry on through the myths. It's a great way of going through some of the misconceptions and misunderstandings around wills. Another one here. I made a will years ago that'll do the job. We've spoken about the importance of revisiting and even redrafting on quite a regular basis and getting into the habit of doing it, right?
Very important to keep your will up to date. I would say you should at least visit your will once a year, at the worst once every 2 years. Circumstances change. People have children, they've named children in their will to be beneficiaries. They then have another child, they haven't mentioned that child. They get divorced, they don't change their wills. They have fallouts with children, and those children end up inheriting because they haven't changed their wills, or vice versa. They have a fallout with the child and remove the child from the will, then make friends again and everything's fine, and don't replace that child. I've had a situation very sadly where things were bad, the father removed the child and he never replaced, and things were very good with the child at the time the father died. So very sadly, so very important you should read your will at least every 6 months and say, if I died today, is this what I wish to happen with my assets? Mm-hmm. If you're happy with that answer and your answer yes, then that's fine. But
still important to do it on a regular basis. Another myth to debunk, my estate isn't dutiable.
Oh, okay. The abatement allowance in an estate is now 7 million, i.e. 3.5 million on the death of the first dying. So if you're married and there's a husband and wife, the first 3.5 million in the husband's estate, if he died first, is exempt from estate duty. However, if his wife is the sole beneficiary of his estate and he dies with an estate of 10 million, the full 10 million going to the spouse will be exempt from estate duty on the death of the first dying. His abatement of 3.5 is carried over to the surviving spouse's estate. So when she dies, now being the last dying, we then look at the 2 estates and we say there's 3.5 million in his estate that was carried over, 3.5 million in her estate that was carried over. So that adds up to the 7 million. Anything over the 7 million is indutable at 20%. Anything over 30 million from the 30 million from the 1st of February 2018 is dutable at 25%. So that's a lot of money. So you need to look at your will very carefully and see when is the best time to pay estate duty. Sometimes if there's going to be a huge growth in assets, maybe then it's wise to pay the estate duty on the death of the first time. But that is something I would go through with the client and look at the time.
And how do you deal with loan accounts? Can you deal specifically with those?
Very important to deal with loan accounts. If you have family trusts and you have loan accounts, that family trust owes you money. Very, very important to deal with that loan account in your will. A lot of people don't deal with loan accounts. A loan account is an asset in your deceased estate. So if you have a loan account to your family trust and the only asset in that family trust is the family home or the family holiday, there's no holiday home, there's no liquid cash in that trust, it can create a huge problem when the executor now calls in that loan account. So you need to deal with your loan account in your will, in that you can bequeath that loan account back to that family trust, which then becomes a contra entry. So the trust owes you the money, you then bequeath it back to the trust. However, you cannot just put a blanket clause in your will and say whatever the loan account is at date of death must go to the family trust. You need to keep that loan account up to date every year when you do your financials. And if it is a 2 million loan account, you need to bequeath the amount of 2 million back to that family trust. So it needs to become a contra entry.
Yeah, let's continue with family trusts then, because another of the myths that we need to discuss is, if I have a family trust, I don't need a will. The two are separate and the one needs to deal with the other.
It can be used as an estate planning tool. Many trusts, unfortunately, exist in name only. So it's not unusual for me to come across a trust that has nothing in it. Somebody's created a trust and they have nothing, or the trust has been dissolved and the trust was the beneficiary of that of the monies in the estate. I had a case a few years ago where the gentleman did everything to his family trust, and unbeknown to me, years later he dissolved that family trust. So at the time of his death, now everything was going to a family trust that had been dissolved. There was no family trust. So his will actually became invalid because he hadn't made provision in the event of that family trust not being there. So we need to marry the trust. We need to know about the trust. We need to know who the beneficiaries are. No use me creating a testamentary trust when there's already a family trust and the beneficiaries are one and the same. So we don't want to run two trusts parallel to each other when you've already made provision for that family trust or in the family trust.
So that comes down to also building a very close relationship with the executor. And this also raises or creates focus on how your spouse or your family know what to do in the event of your death. Again, I reiterate, these are difficult conversations to have with your family, but for everyone's benefit, you have to have them.
Very difficult to have. And I actually really do encourage family participation. At the time of drafting the will, if there is something very specific a child of yours wants from you, for example, anything, a family heirloom that's been in the family for generations, ask the child if they want it and don't bequeath it to somebody that might not want it. So I really do encourage family participation and very little surprises when we come to reading the will. Had a situation just this week where I've got a huge problem in a family because the father had actually discussed his will with the family, and they were all quite familiar with what was going to happen in the event of his death. But he actually changed his mind when he came to do his will, and so it was a huge surprise to the family because it wasn't as per what they had all discussed. So now we've got brothers and sisters that are inheriting different ratios and causing huge problems between those brothers and sisters through no fault of their own, really. Because where the one is inheriting a lot less now, she's not happy about others inheriting. So I do encourage honesty and family participation. It just makes it so much easier for the executor to wind up the estate when everybody's on the same page.
And important that the spouse and family know who the executor is. I mean, there are certainly examples that I can think of personally where that wasn't the case. that friends have not known what to do. So an important topic to carry off.
Correct. I have so many cases where people have a will with a financial institution, say, for example, the bank. They think that the banker whom they've had a personal relationship for many years is the person that's going to wind up the estate. It's not. It's a completely different department. They don't know you at all. So there's no, you're dealing with a call center. There's no personal one-on-one. I really suggest it's so important. And fortunately, I have in my situation a succession plan where I have my daughter in the business with me. So if anything, somebody says to me, anything happens to you, well, I've built a relationship with you. My daughter's in the business with me. So we have a wonderful situation where there is continuance. So I like to go and sit in front of the person or Zoom calls and build that relationship with the person that's going to be deceased, and I'm going to be the executor. So they'll know that, okay, now this is what I discussed with her. It's not somebody that's just a title in a bank.
Nice to know that your daughter also started when she was 15, continuing a good family tradition. Denise,
she's been indoctrinated since she was 4, I think.
There's 2 topics I'd like to quickly, I don't want to gloss over them. I want to deal with them before we get to some very good questions that have come in on the Q&A line. The first of those 2 topics is the concept of a living will. And it's a separate document to your will, but perhaps you can just give some detail on what is a living will, how does it work, and how does it come into force?
Okay, so living will is a separate document to your will stating that you do not want to be kept on life support should a doctor declare you brain dead. You have to be brain dead, no chance of recovery. It's then your wish that you do not be kept alive on life support. A lot of people think that their medical aid will cover the life support costs. Medical aid will only cover your life support costs if there is a chance of you surviving. If there's no chance of you surviving. I had a situation where a gentleman was hijacked. He was shot in the head. The bullet went straight through out the other side. He was clearly brain dead, no chance of recovery. Because he never had a signed living will, they rushed him to hospital. They put him on life support because his heart was still beating. The surviving spouse begged and pleaded for them not to put him on life support because there was no chance of recovery. The hospital then turned around and said, we want a living will or a court order saying that he can't go on to life support. So they put him on life support. He died 10 days later. I did the estate. I got an account of $250,000 for the cost of that life support at $25,000 per day. So I do encourage living wills. A lot of people say that for religious reasons they don't want to sign a living will. But basically, it's man keeping you alive, machine invented by man. Had it not been for the use of that machine keeping you alive, you would have died naturally. So you need to have a look at it. I do encourage it, but it's a very personal situation.
It is personal, but it's an important aspect to cover off with your family as well.
Correct.
So that they understand your wishes and why you are drafting that document.
Even the spouse doesn't have the power to say switch off or don't put him on the machine. So her decision will be considered. But in my case, she had to go to court and make an application, which is going to take more than 10 days unless you bring a very urgent application to court. And that's going to cost a lot of money to bring an urgent application. So it is something really to look at and consider and read the wording of it. It's very strictly worded. Euthanasia is not legal in this country. So you have to be brain dead, no chance of recovery. Also, in the case of people that have very, very severe cancer and are basically, there is no chance of recovery and they're in so much pain that you can, in terms of the living will, request that you be given extra morphine, even if it hastens the moment of death, to be kept free of pain.
So Denise, the last topic I'm going to touch on before we go to Q&A is that of estate planning. And I love your saying that estate planning is like dealing with a backache. And sometimes all it requires is a visit to the chiropractor for an alignment to feel some relief. But it does come back to are evolving circumstances as we go through our lives. Different earning potential, different numbers of dependents, and changing, evolving sets of financial circumstances. So the nature of how we evolve in our financial lives means that estate planning is a fluid process, right?
You need to deal with your personal assets in your estate planning and discuss with your executor. You need to deal with trust assets in that planning. You need to deal with contractual arrangements, how you married, ANC, community property, life policies, buy and sell agreements in businesses, all that type of thing, retirement fund benefits, who the beneficiaries are, which acts would apply. So there's all this type of thing that is so important to deal with at the time of planning your will and your estate.
So give me a checklist. If you had to ask yourself, once a year, if you're saying let's review this at least once a year, what's your little checklist that you need to make sure that you have under control?
Okay, so you need to have do you have an effective estate plan in place? If you died today, are your affairs in order? Does your will clearly set out your wishes? Has your will been executed properly, signed, witnessed, dated? Are you happy with all these things? If you have offshore assets, I do recommend a separate will. So if you have assets in Mauritius, assets in the UK, assets in Australia, we do specific separate wills pertaining to assets in Mauritius, a separate will pertaining to assets in the USA, Australia, wherever. Ask yourself all these questions. Do you have all this in place? And if you don't, that is my job to come along and help you, and we structure something.
And part of that would also be looking at policies and nominees, beneficiaries within those policies, and also checking that you have sufficient provision for liquidity in your estate.
Very, very often I have huge asset portfolios in deceased estates, but very little cash. So unfortunately, all liabilities in a deceased estate have to be met before anything can be passed on to a beneficiary. So in some cases, we have to sell assets. Sometimes it's even the residential property in which the people live. If that's a big asset and there's a huge bond on that property. So I need to know, do you have a policy in place where your liabilities can be met from those proceeds? Have you appointed the right beneficiary of that policy? I've had cases where there's second marriages. The surviving spouse has been appointed as the beneficiary of the policy. However, the matrimonial home has been bequeathed to the children. But there's a bond on the property. So now she's been bequeathed the policy. She's not going to want to pay me the money to pay the bond off. He gets proceeds of the policy, and unfortunately, we have to sell the house to pay for the liability in the deceased estate. So there's all this type of thing. We look at taking out a policy if there's going to be a cash shortfall and making the estate the beneficiary of those proceeds and not a third outsider that I've got to go to now and ask for the funds. And that person that is the beneficiary of the policy is under no obligation to pay the estate liabilities from those funds.
Okay, I'm going to get to some questions that have come in and I suppose put you on the spot, but I think what's become abundantly clear is that you are a fountain of knowledge when it comes to these topics, Denise. So there's a couple of questions in from Courtney. It says, hi Denise, how much is the yearly safekeeping fee?
Free, with ourselves, free.
That's a very simple answer. Thank you. And also, Courtney also asked, if you have money overseas in an offshore bank account, do you need to submit a power of attorney form to the offshore bank prior to death, or will the letters of executorship suffice when bringing the funds back to South Africa?
As I've said, the power of attorney falls away on death. So with regard to your wishes after death, you need to have a will. And then we get probate, which is the same as letters of executorship in any foreign estate. So you need to have an offshore will pertaining to those funds.
Yeah, I think that came through quite clearly, that anybody with offshore assets you highly recommend. And it is, to be clear, it is part of the service that you offer, is both
Correct.
South African and foreign wills.
Correct.
We've got a question from Carl. The first one I'm going to answer because Carl says, how often should one review their will? We've answered that one at least once a year, Carl. And Carl also adds a quick question regarding the example you gave where a person's life partner signed the will as a witness and they were intended to be a beneficiary of the will. If one does not comply with the formalities of the will and the courts can clearly see what the deceased's intention was, is there a way to remedy such a situation?
Yes, you can apply to court, a very, very expensive process. You can apply, but you've got to have a very, very strong case. So if the intention was written down anywhere else or recorded or there's witnesses, all that type of thing. So it would be at the discretion of the court to make a decision with regard to the intention of the deceased. Yes.
A question from Linda Woolley. Can a living will be incorporated in the testamentary will?
No, it's a separate document. A living will is used prior to death. A last will and testament kicks in on the day that you die. So last will and testament becomes cast in stone after death, and a living will is what your wishes are with regard to whilst you're still alive, no matter what state you're in. So it is a separate document.
Okay.
It should be treated as a separate document. I've never incorporated it.
Question from Jackie Simpson. Most policies allow you to nominate beneficiaries, and if you have a will where the distribution of your estate differs, what happens? I think you mentioned that policies are separate. Is it that they sit outside your will? Is that correct?
Yes, completely separate. Only with regard to your wishes and that the monies, but for estate duty purposes. So if you have a life policy and it's going to your child and it's worth 2 million, for estate duty purposes, it is brought into the estate duty calculation because it is a deemed asset in your estate, even though there's a nominated beneficiary. But for estate duty purposes, that 2 million is brought in. And if your estate is dutiable, your child or whoever is the beneficiary of that policy will pay the estate duty to the executor on that portion of their inheritance. So if it's 20% of the 2 million that they receive, they've got to pay that portion to the executor. Yeah. So they are treated separately, but for estate duty purposes, they're brought in to the calculation.
Okay. Next question from Andrew. What is the general typical scenario? And I'm wondering if there is one, because we've spoken around how everyone's circumstances are different. But is there a general typical scenario when deciding what percentage to leave to your spouse, and for example, 2 children, perhaps 1 minor, 1 adult, easiest to leave 100% to your spouse, but that doesn't seem correct? Your comment on that?
You know, everybody's wishes are different. Depends what your wishes are. In a lot of cases where we have second marriages, where the deceased now is wanting to protect the assets for the end beneficiaries being the children, being his children from his previous marriage, but he's also got to look after a second spouse that he's married to. So that's where I would encourage then that we look at moving those assets into a testamentary trust, whereby the surviving spouse would be looked after. She would have a usufruct of those assets until her death, and then on her death, it's guaranteed that that asset will be passed to the children. So it's really, every case is treated differently, and it depends on your wishes. If you want your spouse to have 100% of your estate, that's fine, but there's no guarantee. You can't say in your will she can have 100% of your estate on condition that she leaves it to your children when she dies. Who's going to monitor that? So if you're wanting a protection of assets for end beneficiaries, then the testamentary trust is a very good vehicle to work through.
Question from Sophia. Denise, are you able to assist with the drawing up of a will according to Muslim / Sharia law?
I am, and I have done it. I try to steer clear of it because I'm not a specialist in that field. So really speaking, I prefer that if they spoke to somebody, or normally as they would get the advice and then they would come back to me and give me the instructions to do it. But there are a whole lot of laws that are very, very complicated. So I do steer a little bit clear of that because I'm not a specialist in that field, to be honest.
A question from Renee. How does a living will tie into being an organ donor?
You can deal with your organ donation in terms of your will and express that wish. So a living will is actually a set document. It doesn't deal with the organ donation in terms of the wording that's government gazetted. But I normally deal with the organ donation in my will. But also, you need to have your family know that it's your wish, that it's your intention that your organs be donated. Because very often, I only get informed once the person's passed away and been cremated or buried. And then the family say, oh my gosh, I didn't know you wanted to be an organ donor. So you need to make it known to your family in a separate document.
But organ donation would be dealt with in your will, as opposed to, so the living will is a separate document pertaining to just keeping you alive or not keeping you alive on life support.
Correct. And then organ donation, I do insert a clause if they so wish in their will with regard to organ donation, but I tell them to please notify their family that is the wish, because I don't want to be told too late.
We've got a fascinating question from Jana, who says, please can you chat a bit more around some conditions which we find regularly from those who draft their own wills, often to manipulate the behavior of heirs, and how those are major pitfalls. I think you refer to this as ruling from the grave. Is that
correct?
Is that fair?
Correct. Yeah. I get a lot of cases. I can write a book on that alone, where somebody will make a stipulation when I go along to do a will, and they'll say my daughter can inherit on condition that she doesn't marry out of the Christian faith or the Muslim faith or anything like that. That is trying to rule from the grave. I had a situation a while ago, and the person said to me, he's not joking, that his wife doesn't use her cell phone for a period of 1 year, that she can inherit thereafter. So, there are things that are allowable and there are things that are not allowable, that become ridiculous. So, got to be careful that it doesn't have the will declared invalid if you go beyond the ridiculous. So, yes, I would guide the person when they do make their will as to whether it would be an allowable stipulation or not.
We've got a fascinating one. It's the last one that's come up on the Q&A chat, and we're a couple of minutes away from closing out anyway. Another one from Carl, who says, what is your best practice to leave passwords to accounts on social media, emails, etc.? This is a fascinating question.
Very good question. Okay, when I do a will, I give the client with a copy of their will, I give them a checklist. And on that checklist, I ask them to keep that checklist up to date in their own possession in their filing cabinet. And on that checklist, to record PIN numbers, passwords, that type of thing. Because a lot of these computer cell phones, and they shut down. When the battery's gone flat, they shut down after date of death, and there's nobody that can have access. So I ask them to record that for their family, but that's only disclosed at the time of death. So on that, very important, because we've lost a lot of information on computers, or where computers we haven't been able to get into, or cell phones and that type of thing. So very important to record it for somebody, but it's kept confidential.
Well, Denise, I must say an hour, or close enough to an hour, has flown by, and I'm fascinated. I'm sure everybody is. I think I'd like to summarize by reminding ourselves of the poll, that 63% of the people on the call actually have a will, and another, I think it was 39% of those have not visited that document in under 2 years. And based on what you've told us today, I think we all have a lot of introspection to conduct, but it is timely. I think, in a weird kind of way, this time of uncertainty that we're going through right now globally, all of us, is a reminder of how quickly life can change, and how we need to take responsibility for what we have, and how we leave it when we're not here. And
very true.
I also refer back to your opening statement, which is, this is the most important document that you will sign in your life. So I know your input to our client base is hugely appreciated. You've had a long time association with the firm. I'm going to hand over to Cliff, who I know from the top of the business just really appreciates the work that you do and the level of comfort that you have the ability to bring to a lot of people. Like you say, go to the chiropractor, get aligned. You'll feel so much better for it. And it is about peace of mind. So, Denise, thank you. I'm sure you're going to get a lot of follow-up work after this webinar. And I'd just like to hand over to Cliff briefly.
Thank you, Denise. And you can have my assurance that Denise comes very well referred to us. And the work that she's done for our clients has been invaluable in their lives. She's both ethical, pleasant to deal with, and wonderful to have as part of our Skybound team. So thank you, Denise.
My pleasure. Thank you for those words. Thank you. Thank you, Matt.
Kate.
Thank you, Kate.
Awesome. Yeah, thank you so much, Denise. I'm sure your phone is going to be ringing off the hook as soon as we close up here. But thank you very much for your time. And thank you everyone for joining us. It's wonderful to have over 100 people on the call today. And just as a reminder, if there are any of the webinars that you have missed or you'd like to recap on Denise's or any of the ones that we've had previously, you just have to go to the Skybound website and click on the Media and Insights tab. And then you'll see a whole library of all the previous webinars. So don't miss out. And if you wanted to kind of recap on anything that Denise has said today, it'll be up in the next couple of days. So thank you so much, everyone, for joining us. And a special thank you to Denise, and thank you, Matt and Cliff, and have a great rest of your day.